Daily, and my first guest is our resident ObamaCare expert, editorial board member, Joe Rago. Welcome, Joe. So yesterday's hearing, or today was the second of three hearings of Obamacare before the Supreme Court. Yesterday's hearing, they talked about whether Supreme Court consideration was premature, given that the law doesn't take effect fully until 2014. What did they talk about today, and what was your reaction?
Right. Well, today's argument was about the Affordable Care Act's individual mandate, the requirement that everyone buy health insurance or else pay a penalty. And the at issue was whether this can be justified under the Commerce Clause. Now, everybody's been watching the court with a lot of scrutiny. How are the individual justices going to react? And what we saw today was a lot more hostile take from Justice Stevens, from Justice Scalia, and Justice Roberts than we might have expected. And they're saying, well, hang on a sec. This isn't just a regulation of commerce. It's a regulation intended to create commerce, and that's a police power, and that's reserved to the states. So we saw a lot more skepticism than we might have expected, certainly than I expected.
And that skepticism was noticed not only by people right of center politically, but also people left of center. Jeffrey Toobin, a legal analyst for CNN and a liberal, went so far as to say that the individual mandate might be in trouble based on what he heard today. And he was talking about exchanges like one we're going to play between Justice Alito and the Solicitor General, Donald Verrilli. So let's listen to that.
Do you think there is a market for burial services?
For burial services?
Yes.
Yes, Justice Alito, I think there is.
All right, suppose that you and I walked around downtown Washington at lunch hour and we found a couple of healthy young people and we stopped them and we said, you know what you're doing? You are financing your burial services right now, because eventually you're going to die and somebody's going to have to pay for it. And if you don't have burial insurance or you haven't saved money for it, you're going to shift the cost to somebody else. Isn't that a very artificial way of talking about what somebody is doing? And if that's true, why isn't it equally artificial to say that somebody who's doing absolutely nothing about health care is financing health care services?
I think it's completely different.
Okay, so Joe, Justice Alito brought up burial services and compared it to health care services. What was the point Alito was trying to make?
Well, why is a mandate constitutional for health care, but unconstitutional for any other good or service, right? So what he's trying to get at, what he's trying to prod the Solicitor General to do, is to articulate some kind of limiting principle that separates this particular individual mandate from any other purchase mandate. Now, one of the things the Solicitor General failed utterly to do was to articulate such a principle. The other thing that the justices talked about today and emphasized, certainly among the court's conservatives and even Justice Stevens, was if this is a police power, it doesn't matter if healthcare is different. It could be completely different from the market for burial services, or we talked about the court talked about all types of other things. The market for food, which everyone is going to need eventually.
Cell phones, Chief Justice Roberts.
Right. Any kind of economic activity. Why is this different? And one of what the justices were saying was, even if it was different, why would that matter? It's still a police power that the Constitution gives to the states.
Okay. And by the way, the conventional wisdom is that the administration is going to need one of these one of the four conservatives on the bench in order to win this case. And based on what we heard today, it doesn't have one of them so far.
It possibly could, but all the indications are running in the opposite direction.
Okay. What are they going to focus on tomorrow, John?
We've got double session tomorrow. The morning session focuses on severability, which says if they strike down the individual mandate or some other part of the law, how far will they go in going after its other provisions? One thing that the Affordable Care Act lacks is what's called a severability clause, which says if any one part of this law is found unconstitutional, the other parts will stand. Because of the way the Affordable Care Act was drafted and passed, it lacks some of these technical details. So we'll see a debate on that, and so how connected are the insurance regulations here? If the mandate goes, do we have to lose the other ones, for example?
Well, as a practical matter, if the court were to strike down the individual mandate, can the rest of Obamacare survive?
Certainly, its regulatory scheme would be much less workable than it would. But for instance, if they strike down the individual mandate, what does that say about the Independent Payment Advisory Board? You know, the 15 technocrats who are going to tell Congress how to lower health care costs. We really don't know how. And the appellate circuits have been split all over the place on this question. So it's a little more technical, but still important for the ultimate ramifications of whatever decision the court comes to this summer. The afternoon session is about Medicaid, and what the Florida and the 25 states that are suing say is that by expanding Medicaid without getting our input, you're commandeering our resources. You're essentially conscripting us as agents of the federal government, and therefore upsetting the balance of powers between Washington and the state capitals. So it dovetails with a lot of the same themes that the individual mandate turns on, which is sort of how does the constitutional architecture apply after the Affordable Care Act?
Okay, very quickly, we have less than a minute. There was a new poll out this morning with some interesting findings. We know that ObamaCare has been less and less popular as time has gone on since it's passed. But this poll asked a few extra questions about some of the so-called more popular aspects of the law. Some interesting findings. What can you tell us?
Yeah, well, this is from the Reason Foundation and ROOP, and what they asked were some unusual follow-up questions.
Right.
You know, we always see a ban on pre-existing conditions coverage, for instance, coming out well ahead, and the press corps and Democrats justifiably say, well, look, some parts are unpopular, some parts aren't. What this poll did was said, well, what happens if such regulations would reduce the quality of care, or required a mandate, or would mean raising taxes substantially?
Right.
And what it found was that support dropped dramatically. In the case of lowering quality of care, support for the pre-X ban stands at about 56%. It falls to just 15%. So these provisions that are sort of the saving grace might not be so popular after all when people think about the consequences.
The more people learn about it, the less they like it.
Absolutely.